Joining me now from right outside the courthouse, Andy McCarthy, former assistant U.S. attorney for the Southern District of New York, and Jonathan Turley, professor at GW University Law School. Both are Fox News contributors. Also with me, Shannon Bream, host of Fox News Sunday. Andy, I want to start with you on the question of what the jury actually concluded here. And Jonathan, you were touching on this earlier on Fox. You made a point that the follow-on or bump-up crime to make this a felony was never specified in the jury return that came in the actual verdict itself. Although you just heard Alvin Bragg say that this was he was convicted on essentially a conspiracy to subvert democracy. So who's right here? What was Trump actually convicted of by a unanimous jury?
Well, the charges in the indictment, and I guess formally what will go down in the judgment of conviction, are, as you said, Laura, 34 counts of falsification of business records with fraudulent intent to conceal another crime. That sounds dry. What was pitched to the jury, and was really pitched by Bragg publicly in a very peculiar way from the day the indictment was returned, was this basically a scheme to steal the 2016 election. I sort of stumble over that because what's amazing to me about this is Bragg is an election denier, and he wears it like a badge of honor, even as election denial, we're told, is like the worst thing that you can be in public life. I guess it depends on which election it is. But the reason I say it was very peculiar for day one is usually the prosecutor has the narrative that you want to present to the jury in the indictment. It becomes the framework that you plead the charges in. In a very strange way here, the grand jury returned a fairly bare bones indictment, which just laid out the statutory elements of this business records crime. And coterminously with that, Bragg put out on his own, not through the grand jury, what he called the statement of facts, which was this narrative about basically Trump defrauding the United States out of what would otherwise have been the delight of having the Hillary Clinton presidency. And I don't mean to be too snarky about it. You just need to read it. That's basically what it says. And it relies explicitly on inadmissible evidence against Trump. It relies as a bedrock matter on this idea that Michael Cohen pled guilty to campaign finance violations, and therefore the fact that there was this conspiracy to violate the campaign laws and thereby suppress politically damaging information was like an established fact. And that's certainly how Judge Merchan treated it.
Well, Jonathan, if that's the case, why did Judge Merchan not allow the former FEC commissioner to testify? If this was such an open and shut case of election interference that was aided and abetted by this so-called falsification of the business records by Trump, even though he didn't personally do that, then why not let the jury hear about what the FEC really was thinking on this matter?
Well, you know, Laura, the problem that I saw in that ruling is not that he said that it is his responsibility to say what the law is. That's true. It's up to the trial judge to give those instructions. The problem is that he never gave the instructions. That is, the instructions he gave did not go into any meaningful detail on what would constitute a federal election offense. It had some information, but it was incomplete. And that's why the defense wanted to bring in a legal expert. One of the most telling things that that expert would have brought in, Smith, is he said, look, not only is hush money not a campaign contribution, that's been long established, but even if it were a contribution, it couldn't have been part of a conspiracy to influence this election because it wouldn't have had to been actually revealed until after the election. So that's just a matter of dates. That's a matter of filings that are in the regulations. It's not a matter of interpretation. The jury was never told that. So the jury heard, because Judge Merchan allowed them to hear, the prosecutors state over and over again that it was an established fact that election violations occurred here and that Trump ordered those violations. That included in the closing argument, and many of us were mystified because the judge had given an instruction that Cohen's plea agreement could not be used to impute the guilt of Trump. And then Steinglass, the prosecutor, repeatedly did that, and Judge Merchan would do nothing about it. That's the reason I don't blame this jury. What they heard in that room and the instructions they were given, probably to some of them made it look like they had no choice but to convict. And that's the problem.
Yeah, I mean, I'm not sure even how much it's worth unpacking this, Shannon, because from the get-go, this was a flawed and novel application of this statute. And we all know as lawyers why prosecutors don't like using novel applications of statutes, especially in high-profile cases, because of the possibility, likely possibility, of a reversal. But in this case, they don't seem too concerned about getting reversed. They wanted to get to the result.
Yeah, if the result is to get it done and get a, quote, conviction before the election, then mission accomplished for Alvin Bragg. Remember, when he started talking about this more than a year ago, the indictment coming together, there were people right, left, and center who thought this was a very weak case and a bad decision, a gamble by Alvin Bragg, that many of them, including on the left, did not think would pay off. They knew that it was novel, and yet he was willing to roll the dice. We've seen that New York juries and judges have not been friendly to President Trump, so it's a good jurisdiction for them to try something novel. And you're right, there's a good chance, as we've all talked about many things, that this Trump team will put together for appeal. Many things that they can point to, and even if they ultimately win, it won't matter for this election. It gets you months, maybe years down the road to get to that point, even if you eventually get that conviction overturned. In the meantime, it gives the Biden-Harris campaign a talking point to use about a conviction. And for President Trump, I mean, he just did an interview with Fox News Digital, and he says he's never had more support. We see the website that is supposed to be his fundraising arm is having trouble. Is that because it's overloaded by people who want to weigh in now? This gives him that fresh talking point now, saying that the real verdict comes on November 5th. I would imagine him to keep using that language over and over again and to tell people, if you don't like this verdict, I need you to show up in November.
I want to go back to what I brought up with Andy and also with Jonathan. What Alvin Bragg said tonight, and whether that was really borne out by what the jury concluded, at least what we know about the jury concluded about that bump-up crime to the felony. Watch.
This type of white-collar prosecution is core to what we do at the Manhattan District Attorney's Office. In the 1930s, District Attorney Thomas Dewey ushered in the era of the modern, independent, professional prosecutor. For now nearly 90 years, dedicated professionals in this office have built upon that fine tradition. Donald J. Trump is guilty of 34 counts of falsifying business records in the first degree to conceal a scheme to corrupt the 2016 election.
Andy, do we know that the jury actually unanimously concluded that?
No, that's what they unanimously concluded was the business records convictions. The bit about the, conspiracy to steal the election is Alvin Bragg's narrative about the convictions. But, look, the victors write the history. And, if this gets upheld on appeal, I don't think it will. But if it does, that's how it'll go down in history. It's certainly, Laura, how it'll be written in the press tomorrow.
Jonathan, what precedent does this set going forward for anyone who comes along to challenge an incumbent like Donald Trump? What precedent does this set?
It's not good precedent, and I think that when people, perhaps some who are celebrating tonight, and the celebrations are occurring all around us, I think that some may look back at this and wonder what we've done. because there's great damage here. You know, the reference to Dewey was confusing, in my view. It was maddening. Dewey ran against Truman. He didn't try to put Truman in jail. So I don't see Bragg as a Dewey. I think that this is going to be part of a very troubling legacy for not just Bragg, but for the New York legal system. It's a sad day. And I know that everyone basically fulfilled their narrative tonight, right? I mean, Trump was able to show that there was a political prosecution that gave him very little chance in Manhattan. I think that's pretty accurate. The other side fulfilled their narrative that he is a convicted felon. Those narratives have existed for some time, and the politics of that we'll have to see. But when it comes to the law, I think that we also have to take that leap of faith, to believe that we have a legal system that is stronger than all of this, that the people around here who are celebrating the demise of an individual are going to be disappointed. This isn't necessarily a demise. Trump did not look like he was surprised at all. You know, some defendants look like they're heading to jail. He looked like he was heading to dinner. I mean, he really did not register it. This is going to be a long road.
Yeah.
And we're going to see how it plays out. But I have faith in the legal system.
Well, Andy, Jonathan, and Shannon, all of you, thank you so much.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.